All right, it's time that this was done. And since no one else is doing it, I'm going to do it. We're going to look at whether or not Kyle Rittenhouse, the kid up in Kenosha who shot 3 people, killing 2, injuring the 3rd during the mostly peaceful protests following the Jacob Blake shooting, whether or not he is guilty of being a person in possession of a dangerous weapon while under the age of 18, and then subsequently, whether or not if that crime affects his ability to act in self-defense. Now, I have personally said that doing a criminal act does not condemn you to death and take away your right to defend yourself, okay? But let's go ahead and see what the law says. I encourage you to watch through this entire video if this is a subject that's interesting to you, because we're going to cover all of the relevant law and we're going to go through it point by point on this one. I'm going to do it as fast as possible, but we're going to go through it point by point and see what is actually going on here. So, why am I doing this though? Hey, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. So if you like legal and political news, commentary, opinion, analysis, all of that stuff, hit the subscribe button, hit the notification bell. Don't miss any videos. And this one especially, don't miss this one. You're here, so you're doing well. All right. We're looking specifically at count 6 today. All of the other counts might get individual videos, but this one I have seen as I talk about Kyle's case, I see people say this constantly. Well, he was committing a crime because he was a kid carrying a gun. He's under 18. That's a crime in Wisconsin. And because he's carrying a crime, he can't claim self-defense. There's a lot wrong with that sentence. Let's just get that out there. There's a whole lot wrong with that opinion. It's incorrect on almost every point. And let's start with whether or not he is guilty of this crime. This is count 6. He is charged with this crime. He will have to defend against this crime in court. Let's see how they're going to do it. All right. So count 6, the above named defendant on or about Tuesday, August 25th, 2020, in the city of Kenosha, Kenosha County, Wisconsin, being a person under 18 years of age, did go armed with a dangerous weapon, contrary to section 948.602A, 939.513A Wisconsin statutes, a class A misdemeanor, and upon conviction may be fined not more than $10,000 or imprisoned not more than 9 months or both. Let me dispel something real quick. 939.513A is just a sentencing statute. So it says if a person is guilty of this, that's where they're getting the $10,000 or not more than 9 months. It has no substantive legal bearing on whether or not he's guilty. The statute we're going to look at is 948.60. Okay? Here it is. Possession of a dangerous weapon by a person under 18. Briefly, looking back at this count, we want to just say, okay, so Tuesday, August 25th in the city of Kenosha, Kenosha County, Wisconsin. So they've got the time, the place that this happened, and then the facts. He's a person under 18 years of age, and he was armed with a dangerous weapon. He had a rifle. So then we have to see if he had a dangerous weapon, and then if that possession is a crime. All right, so here we look to the statute. And the good thing about this is all of this analysis is encapsulated in this statute for this crime. Basically, there's 3 other reference statutes that we'll look at, but pretty much everything we need is right here. Okay? So, first, in this section, dangerous weapon means any firearm, loaded or unloaded. Full stop. We don't care about electric weapons. We don't care about nunchucks. We don't care about knives or sticks or anything like that. We're talking about a firearm that is loaded and then was unloaded. That's a joke. Okay, so a firearm that was loaded. That is a dangerous weapon under the statute. So now we can move on. We don't need the rest of this paragraph. Any person under 18 years of age who possesses or goes armed with a firearm that is loaded is guilty of a Class A misdemeanor. We could just substitute that language in there. Except as provided in paragraph C, any person who intentionally sells, loans, or gives dangerous weapon to a person under 18 years of age is guilty of a Class I felony. That's not relevant to Kyle, but it is relevant to other people in this case. Whoever violates paragraph B is guilty of a Class H felony if the person under 18 years of age under paragraph B discharges a firearm and the discharge causes the death to himself, herself, or another. Remember, that is actually relevant to another person who's been charged in relation to this, the person who gave Kyle the rifle, but not Kyle. D, a person under 17 years of age who has violated this subsection is subject to the provisions of Chapter 938, blah, blah, blah. He's not under 17. He was 17 at the time that this occurred. So we can ignore paragraph D, doesn't pertain to Kyle, but it's really that they're prosecuted under the juvenile court's jurisdiction. Okay, so now we get to the next thing. It's pretty straightforward so far, right? If you are under 18 and carrying around a firearm that is loaded or unloaded, you are guilty. This is a strict liability. Doesn't mean if you're intending to do it. It means if you're in possession of it, if you have it on your person, you're guilty. But there's always a but. 3A. This section does not apply to a person under 18 years of age who possesses or is armed with a dangerous weapon when the weapon is used in target practice under the supervision of an adult or in the course of instruction in the traditional and proper use of a dangerous weapon under the supervision of an adult. This doesn't really apply, right? They're not at the range here. They don't have paper targets set up. I mean, you could argue that he quickly threw a paper target up on someone and then an adult came by and was like, aim for center mass. That's not what happened. So we don't have target practice exceptions here. Not a big deal. We can skip that section. Section B does not apply to a person under 18 years of age who's a member of the Armed Forces or National Guard. No evidence that I've seen says that Kyle Rittenhouse is part of the Armed Forces or National Guard. So we get to skip that one too. Now, on to the one that matters. And I want you to know that there's some weird theories out there about how this only applies to this subdivision 3 or whatever. That's all entirely wrong. Subdivision 3 is the exception subdivision here. We've got subdivision 1, which is definitions. Subdivision 2, which is the criminal acts that are assigned under this statute. And then we've got subdivision 3, the exceptions to the statute. 3C, this section applies only. It only applies. Section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28 or is not in compliance with sections 29.304 and 29.593. Okay, so if you have a firearm that is a rifle or a shotgun, it only applies if you're in violation of one of these 3 sections. So we have to figure that out. Notice that if you have a pistol or a cannon or a howitzer, those things are still dangerous weapons under the statute because those are firearms and those firearms are loaded or unloaded. But if you are in possession of a rifle or a shotgun, then we have to check if you're in violation of these 3 statutes. So, next step. First one, 941.28. Here we go. Possession of a short-barreled shotgun or short-barreled rifle. If you're familiar with your Second Amendment sort of case law, you know that a short-barreled shotgun and a short-barreled rifle are presumptively unlawful in general. These things are regulated by the National Firearms Act. You cannot have a sawed-off shotgun. You cannot have a rifle that has too short of a barrel. So, let's see what this means. In this section, a rifle means a firearm designed or redesigned, made or remade, and intended to be fired from the shoulder or hip, and designed or redesigned and made or remade to use the energy of a propellant and a metallic cartridge to fire through a rifled barrel, a single projectile for each pull of the trigger. So a non-automatic weapon. That's what we're looking for. Either a lever action, a bolt action, or a semi-automatic, one pull, one bullet, period, through a rifled barrel. Okay, fired from the hip or shoulder. A short-barreled rifle means a rifle having one or more barrels having a length of less than 16 inches measured from closed breech or bolt face to muzzle, or a rifle having an overall length of less than 26 inches. Both of these apply. Both of these apply. Either the entire firearm is less than 26 inches, or from the breech, the closed breech or bolt face to the muzzle is less than 16 inches. Either one of those. But both of those have to apply. Let me be clear on that. If you have a 30-inch overall rifle, but the barrel length is only 2 inches, guess what? You're over 26 inches. And so that's important. Short-barreled shotgun doesn't matter. We know that Kyle was arrested with a Smith & Wesson, or he's accused of carrying, a Smith & Wesson M&P AR-15 style gun, and we're going to look at that in just a minute, okay? But he wasn't accused of carrying or using a shotgun. So, no person may sell or offer to sell, transport, purchase, or possess or go armed with a short-barreled shotgun or short-barrel rifle. No one can have this. It's not just a minor. Nobody can. So what does this section say? It says a person under 18 can carry a rifle or a shotgun so long as it's not the illegal rifle and shotgun. That's what it says. So we've already gone ahead and eliminated this cause of action. Basically, we're going to go through the other two statutes for completeness. If this is not a short barrel rifle, Kyle is fully legally within his rights to have this gun. A 17-year-old in Wisconsin can carry a gun, a rifle, or a shotgun. They can have it. I don't know what else to tell you. So, this is all about short-barreled rifles and shotguns. Any firearm seized under this section is subject to section 968.20 and is presumed to be contraband. So if it's seized under this, it's presumed contraband and you have to defend against it. Just having this gun, no matter how old you are, would be illegal. Kyle is not charged with this. Kyle's not charged with this statute, and he would be. This would be a slam dunk charge. This would be an illegal gun. They made these illegal back when the mob was around, or the early mob during Prohibition was around because of Tommy guns and sawed-off shotguns. That's why these laws exist. Kyle would be violating the law just by having this gun, no matter if he was 50. It doesn't matter. But let's take a look at the stats and see if this gun, the Smith & Wesson M&P 15, matches up. Here's the Wikipedia page. There's a possibility somewhere that this gun was modified, that Kyle's particular gun was modified. I've seen the pictures. You've seen the pictures. It wasn't modified. This is a standard length barrel. And here we go. The length collapsed. Overall length of the gun, 32 inches. Extended, this is the stock, has a collapsible or extending stock. If it's extended, 35 inches. Both of those are well in excess of the 26-inch requirement. And the barrel length is, of course, 16 inches because you can't buy a shorter barrel in Wisconsin with this gun. Like, you would have to modify it. You'd have to put on a 12-inch barrel or something. But guess what? Even if you put on a 12-inch barrel, you're still over 26 inches. So we have basically, outside of some crazy modification, and again, if you look at the pictures, it's going to look like that gun. It's not going to look like a different gun. If you look at the pictures, that's what it looks like. So outside of some unforeseen or unknown modification to the rifle, he's not in possession of a short-barreled rifle. So now we move on to these other statutes. Here's 92.304. Restrictions on hunting and use of firearms by persons under 16 years of age. We can disqualify that immediately. 1, Kyle's not hunting. 2, he's not under 16 years of age. This section doesn't apply. So here we go. Moving on to the last legal section that we need to look at. 29.593. Requirement for certificate of accomplishment to obtain hunting approval. Kyle Rittenhouse, aside from jokes and memes, is not actually hunting here. He is not required to have hunting approval for his activity of being in Kenosha and carrying a rifle. That is not a hunting activity. That is just carrying a rifle, having a rifle in your possession. So we don't need to go through this either. We go back to the statute. So again, This section, let's translate this with some algebra. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of having a short-barreled rifle or is not in compliance with being over 16 years of age and not having a proper hunting license while engaged in hunting. Kyle Rittenhouse is not guilty of count 6. He's not guilty. There is no factual way. There is no reasonable jury on earth that can convict Kyle Rittenhouse of this offense because at the time of the crime, he was 17 years of age. He was carrying a rifle, and that section does not apply. If he were somehow miraculously convicted by a jury on this, he should be able to have that thrown out, as no reasonable jury can conclude that these facts fit into this law. It's not possible. I can't stress this enough. It can't go this way. It's not possible for the law to make Kyle Rittenhouse guilty of this crime. He's not guilty of count 6. But let's go to one more hypothetical. Just to go ahead and dispel this, this is the last part. Remember I said people are saying, well, because he's guilty of this crime, then therefore he loses his right to self-defense. Now, presumably, that would apply to other crimes as well. So let's look at the self-defense law here in Wisconsin, okay? This is what we're looking at. This is the provocation affecting the privilege of self-defense. You have the privilege of self-defense unless you provoke an attack. You can't provoke someone to attack you and then defend yourself. That's not how it works. Or can you? Really quickly, a person who engages in unlawful conduct of a type likely to provoke others to attack him or her and thereby does provoke an attack is not entitled to claim the privilege of self-defense against such attack. Okay. Except when the attack which ensues is of a type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. In such a case, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant unless the person reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm at the hands of his or her assailant. Okay, really quickly, if you believe you are going to die after provoking an attack, guess what? You don't have to die because the law isn't that stupid. The law recognizes that, you might have tried to provoke someone to punch you. You're getting in a bar fight or something like that. You're like, hey, you're fat or whatever. And the person starts throwing hands. If that person pulls out a knife or a gun, you can defend yourself. Here's what it adds. It adds a duty to retreat. The duty to retreat does not exist in the state of Wisconsin. You have no duty to retreat, except if you provoke an attack, that attack turns deadly, and you need to defend yourself. You must have exhausted your duty to retreat at that point. That's the only place where it exhausts a duty to retreat. Here's the thing. Kyle Rittenhouse was retreating the entire time. So even if you argue he was provoking the attack, he retreated from Joseph Rosenbaum. He retreated from Kelly Huber. I think Kelly's his name. He retreated from Gage. He couldn't retreat from Gage Groskowitz or whatever that guy's name is because he's laying on the ground at the time that guy comes up to him. He can't retreat anymore. This is just not a winning argument, folks. Kyle Rittenhouse was not committing a crime by carrying a rifle in Kenosha on Tuesday, August 25th, 2020, as a 17-year-old. It's not in the law. And even if it were a crime or if there's some other criminal act, they just have to prove that he exhausted his duty to retreat, which he did. But here's the problem. There's no other criminal act other than the act of firing the gun. There is no provocation argument from the prosecution at this point. They'll have to argue that each individual act was its own criminal thing. There's no other criminal activity than being possession of a dangerous weapon. Sorry, folks. That's how it goes. Kyle Rittenhouse is definitely not guilty of count 6. Under Wisconsin law, you've been through every single wording of the legislation that matters in regards to this count. You can now share this video to anybody who says that Kyle Rittenhouse was guilty as a minor of carrying a firearm. He was not. And no reasonable jury could find it. And if some jury were to find him guilty of this, he would be able to have that jury decision overturned, probably at the district court level. And if not, he could definitely appeal it. But he won't be found guilty of this because the facts don't fit the law. Anyway, hope you found this informative and interesting. Please drop a comment down below. Tell me what you think about it. Tell me what you thought about it, whatever that may be. And let's talk soon. Again, if you haven't subscribed yet, why not? Hit it. Peace. Peace.